This is WealthBT, a podcast of BT correspondents.
Disputes over the contents of a will are not uncommon. The ones that make the headlines usually have an interesting twist. In a recent case, a daughter challenged her father's will because the first will named her as the sole beneficiary of a multi-million-dollar house. But a second will surfaced, where the house was instead given to her brother. The court found in favor of the brother, so you can only imagine the state of family ties after such a dispute. In this episode, we'll look into some important aspects of drafting a will. How essential is it to engage a lawyer to do this? If your wishes are similar to the Interstate Succession Act, which governs distribution if there is no will, should you still write a will? How airtight is a will in case of a dispute versus a trust? Welcome to WealthBT. I'm your host, Genevieve Cua, Wealth Editor of the Business Times. Every week, my colleagues and I break down a business story that matters. My guest in the studio is Boon of Marini Law Corporation. Thanks for coming by to the studio, Boon.
Hi, thanks, Genevieve.
Boon, you're seeing a change in attitudes among younger Singaporeans on estate planning, that they're doing so at the younger ages. What's driving this shift?
It will be due to a few factors. One could be the higher financial literacy rate across Singapore, and more Singaporeans understand that drafting a will is part of the estate planning, and people are moving away from the stigma that drafting a will in place is unlucky. Another part will be a social norm change. There are increasing couples that decided to just remain as domestic partners instead of entering to the marriage, LGBT couples, single moms. So this group will have to leverage on the tools such as will in order to distribute their assets to their loved ones.
So when we say younger, how young is this?
There's an increasing trend where young couples in their late 30s, early 40s, with one or two kids, they will start to do a will. And this has moved away from the perspective that you think that, only those who are at their 60s will start to do their will. So time has changed.
At the moment, anyone can DIY a will using some social tools. What are the pros and cons of that?
Well, will is a legal tool, and not necessary that you have to engage a law firm to do it. You can always draft it yourself. Of course, drafting a will through those DIY or online platform is cheaper. However, it's best advised to approach a law firm to have your will drafted. The reason is that the law firm will ensure that there will be proper execution of the will, and the lawyers can act as a credible, independent witness. There will be less chance of ambiguous language, and of course, also whether to advise what type of assets to be included in the will.
Some people may think, I don't mind if my assets are distributed according to what happens when you don't have a will, which means it's governed by the Interstate Succession Act. So why bother then? And what actually happens if there is no will?
So one of the benefits of having a will, which a lot of people overlook, is that you can state who is your trustee for the will. The role for the trustee is the one who will apply for the grant of probate and subsequently distribute the assets in accordance to the will. And it's actually a very important role. For example, a father whose wife has already passed on, has two sons. According to the interstate, each of his sons will get 50% each, even if he don't do a will. And by doing a will, he can choose who to be the trustee. And in this case, he can choose the one who he feels is more appropriate, more thoughtful, has the capability to handle the distribution.
So let's say you don't have a will. So just to be clear, who gets what? Your spouse, surviving spouse gets 50%, and the balance is
split among the children. So if your spouse has already passed on, then the distribution will be 100% for the children.
Yes, equally distributed.
Correct.
So what are the most important considerations in planning your estate or distributions?
I've mentioned it before. It's very important to choose who is the trustee. So that's one. Two is also in terms of drafting the will. If you do it yourself, you must make sure that the witness is clear of conflict of interest. The last thing you want to do is you draft a will and then you have two witnesses that is the beneficiary listed in the will or spouse of the beneficiary of the will. And of course, I always advise my client when they draft their will, do keep a schedule of assets. So basically, you list out all the assets and put it together with the will so that when your trustee trying to get the will and apply for the grant of probate, he is able to distribute the assets, knowing what assets are being left behind.
Right. How often should your will be revisited? And how important is it to revisit this?
It seems that there are still misconceptions by most people that, I make a will and do it once, do it good, that's it. That's really not the case. Different milestone, things change. So for example, if you are in your early 30s, you are married, no kids, so you may want to apportion your assets between your wife and your parents. But subsequently, with you reach a milestone with children, you may still want to apportion more to your spouse so that your kids can be well taken care of. But if you are in your 50s or in your 60s or even in your 70s, you may want to move away where you want to make sure that you have more money for your child or even your grandchildren. So things will change along the way.
So would it make sense to actually tell your children that my will is here, and by the way, I made a new will as well later, What do you think?
First of all, it's important to let your trustee know that they are the trustee of your will. I think that's the very important bit. There are a few occasions where the son wasn't aware that the father makes a will until the father passes on. They open up the safe box in the house. Then they realize, actually my dad does make a will and I'm the trustee. So it's important to let your trustee know that they are the trustee and have their consent.
A will can be as airtight as a trust. If you already have a will, should you bother establishing a trust, and vice versa? More on that in a moment.
Lens on Singapore is now bigger and better. The same deep dive exploration of socioeconomic and geopolitical issues which impact our lives here in Singapore and the region is now a video podcast. If watching a conversation is your thing, join Clarissa Montero in monthly conversations about things that matter. Subscribe to the BT Lens On playlist in the podcast tab of the Business Times YouTube channel and start watching today. BT Lens On Singapore, now available in audio and video.
And now, back to WealthBT, a podcast of BT correspondents.
Welcome back. Boon, in your experience and in the context of cases that have gone to court, what are the most common mistakes or misconceptions that make a will vulnerable to disputes? So I'd like to take on a point that you mentioned earlier, that social norms are changing. People don't get married, for example, or they may be LGBTQ or whatever, right?
Yes.
What are your thoughts here?
Via the Interstate Succession Act, the distribution that not necessarily will allow the loved ones to inherit the assets. So in order for the assets to be given to their loved ones, especially if they are in that category of LGBTQ couples, domestic partners relationship, or even single mom, it's important that you make a will so that these assets can be distributed to your loved ones. I'll quote an example. So what happened is that the mother passes away, and before that, the mother has divorced with my client's father. After the divorce, the mother has also given birth to two other daughters, which is my client's half-sister, and the mother is not married to the sister's father. So in this case, the two younger sisters of my client are considered as illegitimate child because they are born out of wedlock. And the mother, because she didn't do a will, when the mother passes on, the only person that is eligible to inherit the estate will be my client, which is the son.
So in this case, the misconception is basically not to take for granted the legal status of your...
Yes, correct. Actually, one very important point I would like to highlight is this single mom. If they want to pass on their assets to their children, it's important that she either makes a will, so that's one. Two is she may have to consider adopting her own children because unfortunately under the law is considered as illegitimate child.
That's despite that the birth certificate would have or might have named a father.
Yes, and you can even do a DNA test to certify that they are mother and child, but the child unfortunately does not have a legal standing and it will be considered as an illegitimate child.
Okay, so in your experience advising on family matters, how open are parents to discussing such matters with their children, and do you recommend it?
So time has changed. I do see an increasing trend where elderly is moving away, where I make a will but I keep it very secretive. Only upon my last breath, then the will can only be surfaced out. But there's an increasing trend where when they make their will, they come to my law firm first, draft out the will, and on the day of the signing, he probably call upon all his children to come along and say, look, this is the content of the will. I'm going to do it this way. If you need any explanation, I can explain to you why is it so. And they will handle it in a more transparent way with hope that there will be less dispute down the road.
You've mentioned that a will is a trust. Can you walk us through that? Like, if you have a will, is a trust necessary? Or if you have a trust, do you still need a will?
This a lot depending on the individual circumstances. A will, the condition is that the person who makes the will passes on. What are the scenario that people, beside doing the will, still need an additional trust? Usually they want to place some assets into the trust first while the individual is still alive, and then maybe disperse them at interval to the beneficiary. Or they have other consideration where they want to move out certain asset into the trust from their individual names prior to their death.
In terms of legal challenges to a will or a trust, I mean, which is more airtight?
Of course, how airtight it will be a lot depending on how the drafting of the will and the trust. So this is where it's important to get a lawyer so that you have less ambiguous language inside. So that's one. Two is also the selection of the trustee. So you make sure that you select the correct people who is fair, just, and has the capability to handle the distribution or manage the trust. And of course, whoever make the will and the trust, they must be very clear what do they want to achieve out of this so that the drafting can be clear and the trustee can able to carry out the execution.
Thank you, Boon, for dropping in and spending some time with us.
Yeah, my pleasure.
Have you done your estate planning yet? Personally, I have to revisit my will because it was done maybe 20 years ago and things have changed. I hope this episode prompts you to take action or revisit your will and other estate arrangements. What you definitely don't want is any dispute that could ruin family relationships after you are gone. For this reason, it's good to be able to discuss things openly with your children on your wishes and arrangements. BT Correspondence will be back next week with an episode on transport. Until the next time, I'm Genevieve Cua. Thank you for listening.
This is a podcast by the Business Times. Find more BT podcasts at businesstimes.com.sg/podcasts or wherever you get your podcasts. This podcast is meant to provide general information only. SPH Media accepts no liability for loss arising from any reliance on the podcast or use of third parties' products and services. Please consult professional advisors for independent advice.